Earlier to that. Earlier to that.
All right.
One para earlier. Their
Yes,
lordships
sir, yes.
Their lordships think it of the utmost importance that those who have thus sanctioned a long possession should not be allowed lightly to disturb it or to escape from those legitimate inferences and presumptions which on a conflict of evidence arise from their own acts and conduct. They may further remark that according to the Mohammedan law, there may be a renunciation of the right to inherit, and that such a renunciation need not be expressed, but may be implied from the ceasing or desisting from prosecuting a claim maintainable against another. Their lordships do not say that in this case the point was not taken in the court below. The acts and omissions of the respondent can be taken up to afford an implication of actual renunciation. So can we come to next paragraph? Next, I mean last sentence in the same paragraph. Next page.
Yes.
They have to choose between the cause for the plaintiff corroborated merely by those slight inferences which arise from the depositions already considered, and the case of the defendant corroborated by the very strong presumption arising from the conduct and acts of the respondent. They have already stated, in their opinion, Southern Court has given more effect than ought to be given to the proceedings in the suit of 1832. They think that court has not given sufficient weight to the presumptions arising from the respondent's conduct, and therefore, though unwilling, even when there is a conflict between the two courts below, to disturb the final finding of an issue of fact, they feel bound to say that in their judgment, the respondent has failed to establish the title upon which he sued, and therefore, Jilla Judge was right in dismissing this suit. So this is how the Privy Council said. Thereafterwards, the Honorable Supreme Court had occasion to consider this aspect of the matter.
Which is that?
Yeah, 1973 Supreme Court, page 554.
(1973)
1973 Supreme Court, page 554.
Idea?
Is
Yes, Chetan. Idea.
Along with a memo, it was placed on the earlier occasion.
Nothing is here. That's the reason. Anyway, here is sir. You can read.
Yeah. Para 11 at page 557. This is how it reads. Quote, it may be mentioned in Muslim jurisprudence, where theology and moral concepts are found sometimes mingled with secular utilitarian legal principles, contains a very elaborate theory of acts which are good because they proceed from Hana, those which are bad because they exhibit Kuba, and those which are neutral per se. It classifies them according to the varying degrees of approval or disapproval attached to them. The renunciation of a supposed right based upon expectancy could not, by any test found there, be considered prohibited. The binding force in future, kindly mark this, the binding force in future of such renunciation would, even according to the strict Muslim jurisprudence, depend upon the attendant circumstances and the whole course of conduct of which it forms a part. In other words, the principle of an equitable establishment, far from being opposed to any principle of Muslim law, will be found on investigation to be completely in consonance with it. Then para 13. Incidentally, we may observe Muhammad Ali Khan versus Nisar Ali Khan, year 1928, Aud 67, has relied upon Harmut Ali Nisam Begum's case, which I cited a minute ago.
Yes.
To hold, according to Mohammedan law, there may be renunciation of a right of inheritance, and such renunciation need not be expressed, but may be implied from the seizing or desisting from prosecuting a claim maintainable against another. As we are clearly of the opinion that they proceed on the basis of estoppel. So this is what the Honorable Supreme Court has also recognized. In the instant case, admittedly, the claim relates to a date of 10/12/2008.
Yes.
After the death of the mother. And She claims.
No, according to you, cause of action arose in 2008?
No, it is the admitted case. It is the plaintiff's case that the cause of action arose on the death of her mother on 10/12/2008.
Paragraph 6 of the plaint.
Yeah.
22, my lord. 22.
6 also, 22. 22 is description of cause of action.
Yes, ma'am.
All right. Hmm.
And the suit is filed on 19/9/2016 after a long lapse of 7 years and 9 months.
So you're on limitation.
It is not a question of it is not.
You're on two aspects. One is renunciation and limitation.
Yes, yes.
Yes,
Renunciation according to Muslim law.
correct.
This is a well recognized principle of renunciation.
Hmm.
If a person does not claim inheritance within a reasonable period, then he or she is deemed to have renounced that claim and therefore not entitled. Now, this is a all-important question of Muslim law, which needs to be considered by this House.
Yes, yes.
Please, my lord. Now, my lord, the learned senior counsel has pointed drawn your lordship's attention to a judgment. I'll just take your lordship to that first.
Of the Privy Council.
Please, my lord.
Yes.
It's 1871 judgment.
1871.
Yes.
Yes.
That's the para that he read out.
Yes.
Now, the same para, my lord, that last para on internal page 10.
Yes.
It says, my lord, they may further remark that according to the Mohammedan law, there may be a renunciation of the right to inherit, and that such